Hi, I'm going to introduce some elements of Section 512 and tee up the discussion for class. The lessons for today are about rules, here represented by the DMCA Section 512, versus standards, here the common law. On the one hand, under a good standard, it is possible to make a lot of decent predictions. On the other, there is no rule so well defined that it can't be made subject to a pitched battle when enough money is at stake. The legislative solution to the prospect of limitless ISP liability was Section 512, which supposedly left the common law of secondary liability intact, or at least most of it. So I'm going to just talk about the key parts of the statute. There are 3 points to start with. There is a broad definition of a service provider. So basically, almost anyone online is going to be a service provider if they aren't the end user themselves. The service provider is not liable for infringement. So what types of liability does this cover? The possible types are vicarious, contributory, including inducement or material contribution plus knowledge, and even the possibility of direct liability. Courts so far have held that 512 covers them all, although of course some of the requirements of 512, like avoiding red flag knowledge, may overlap with the requirements to avoid inducement. So that doesn't mean that 512 protects you from inducement liability if it's made out, but it's for 512 specific reasons. 512 protects only against monetary remedies, not against injunctions. A recent case held that under 512J, the available injunction can only cover specific links. It cannot impose an obligation to find and get rid of infringing content wherever it is on your system. That is, any injunction can only replicate exactly what notice and takedown does, which means these injunctions are useless. Consider the potential consequences, though, if a court had ruled to the contrary, that an injunction could require filtering. That would have been pretty much in tension with the statutory scheme as well. Complying with the DMC is not mandatory, so the OSP could still say it wasn't liable for common law reasons, although it is less and less clear that that actually works, as courts have come to expect DMCA compliance. To qualify for the safe harbors, the OSP must have minimal involvement in infringement, although the requirements vary by section. So starting with transmission or transient storage, this codifies the holding of Netcom. The material must be sent at the user's direction, the content unmodified and unavailable to anyone but recipients. This protects email providers. Then there is a special protection for system caching. The thought in 1998 was that because of slow network speeds, many ISPs engaged in local storage of frequently accessed pages, like the front page of the New York Times, so they'd load faster. The scenario in the statute is user A requests a web page, ISP caches the content. After that, user B requests the same page. The ISP provides the cached content rather than going all the way to the other server. Google's cache is only like that accidentally. If you're the first person to request the page from Google, Google appears to fall outside the safe harbor. That hasn't stopped one court from finding that Google's cache functions are within the safe harbor, though. Information storage at the direction of the user. This was supposed to be the most important provision. It is very important to YouTube and similar services. A couple of points. You can see here, and not in the 2 previous safe harbors, classic concepts from the common law. But as the cases say, some of these concepts might have to be modified from their common law meaning to make the statute work. We'll spend some time on that in class. Congress expected that infringing material would be uploaded to the web, and did not anticipate the development of Napster and other services where content was shared from individual hard drives. Among other things, this means that the provisions of 512 for subpoenaing ISPs for the identity of infringing subscribers only covers Part C. It does not cover Part A, making the subpoena provision nearly useless for ordinary file sharing, P2P or BitTorrent type file sharing. As a result, copyright owners have instead filed a lot of John Doe lawsuits against BitTorrent users. After the lawsuit is filed, they can often get the ISP to disclose the identity of the person who is using the relevant IP address at the relevant time, but it's more expensive. Finally, information location tools. This is the main protection for Google search engine, which content owners hate with a singular passion. There we'll talk more about the details in class, but there are 2 general requirements for all 4 safe harbors. You don't interfere with technical measures applied by copyright owners. Nobody does this, so it doesn't really matter. And you must terminate repeat infringers. There are also additional requirements for eligibility for C and D. Recall that the common law of vicarious liability has expansive interpretations of both direct financial benefit and right and ability to control. So if having a notice and takedown system gives you the right and ability to control the activity, then complying with notice and takedown would seem to take you outside of C and D. And you'll see courts have not actually gone that far. In addition, the limitation of liability under C and D is conditioned on lack of knowledge. Moreover, to be eligible for C and D, the OSP must designate an agent for notice of claimed infringement. That must be available on its site and filed with the Copyright Office. The theory is you should invite such notices. The Copyright Office a couple years back decided that OSPs would have to refile every 2 years or their designations would expire. I think they have no statutory authority to do this, but no one is sued. Remember the role of knowledge in contributory infringement. The key thing is that this provision clarifies what an OSP must do when it gets knowledge. Removal satisfies its obligation. Recall also that in the internet context, there will often, if not always, be material contribution. So knowledge is the key limit. So let's talk a bit about the operation of notice and takedown. Proper notice has to identify the infringing material sufficiently for the ISP to identify it, including its location. And this raises the question of the legal effect of an insufficient notice that doesn't contain all the necessary information. Can a copyright owner use bad notice to show that the OSP had the requisite knowledge? This is a really important part. 512 provides the mechanism for copyright owners to provide knowledge. If they get it wrong, that will generally be inadmissible as evidence of knowledge. Otherwise, the statutory notification requirements could be easily evaded by claiming that improper notice still provided knowledge. The content of the notice has to state that the complaining party has a good faith belief that the material is unauthorized by the copyright owner or the law. The only part of the statement that has to be made under penalty of perjury is that the sender is authorized to act by the copyright owner, not that it was unauthorized by the copyright owner or the law. In order to avoid liability to the subscriber as the result of the removal, the OSP must act in good faith and take reasonable steps to promptly notify the subscriber that it removed or disabled access to the material. However, the OSP is not prohibited from modifying this provision by contract, and so everybody does so, and provide that they aren't liable to the subscriber no matter how much they screw up a takedown. If the subscriber sends the OSP a counter notification that there's been a mistake or misidentification of the material, the OSP must promptly notify the copyright owner that it'll replace the material in 10 business days. The OSP must then replace the material not less than 10, nor more than 14 business days after receiving a counter notification, which means there's a mandatory period of 10 business days during which the material is unavailable, no matter how mistaken the notice was. After 14 days, it has to go back up, unless first, it's modified by contract, which it is for some big providers, or second, the copyright owner sends notice that it has filed an action seeking a court order to restrain the subscriber. Google has a number of side deals with large copyright owners, mostly music companies, to allow them to override counter notifications at will, even if the use is a fair use. This all happens without any judicial determination of infringement. It is, in essence, a TRO without any judicial involvement. Thus, many courts have been inclined to enforce the notice requirement strictly when somebody has sent a not good enough notice and then claims that the OSP is an infringer. In addition, courts have generally not been bothered by Google's practice of scrutinizing notices for substantive defects and refusing to act when, in Google's judgment, no infringing material is to be found at the identified URL. That is, if you sue Google, you have to show that it ignored your notice. The fact that it ignores a bunch of other notices does not disentitle it from the safe harbor when it does comply with the notice. Now, the Copyright Office has expressed its doubt about this, but given how many bad notices there are, this is clearly the right result, and no court has really expressed interest in finding to the contrary. So there has been an empirical study, actually a number of empirical studies of takedowns, mostly centering around Google, because Google offers the most transparency. Around 30% of notices had problems, mostly that the content identified didn't seem to be at the URL identified. There were a non-trivial number of cases that seemed to be fair uses, including people trying to get rid of content they considered defamatory, competitors' content, and pictures of themselves in which they didn't own the copyright. There are even schemes in which a person who's targeting the poster for suppression will copy a post it somewhere else, then identify themselves as the copyright owner of the copied post and send a takedown notice. Because of the repeat infringer provisions, if you do this a few times successfully, you can get a critic shut down. Now, remember that this is in the context of billions of notices, most of which target valid infringing content. Copyright owners also say that most of that 30% is not harmful because either there's nothing at the identified location or there's something else that's infringing. And that is probably often true. Very few people file counter notifications, less than 0.01%. Large copyright owners contend too that most counter notifications are in fact abusive. They rely on the reality that most copyright owners won't bother to sue someone who's actually in Bulgaria. I expect there's some truth to this, but I don't trust their evaluations of what counts as valid counter notification, given that they barely admit that fair use exists. There are larger problems with the DMCA regime, which, although I tend to think it's the least worst option. But it is true that the whack-a-mole of takedowns can require either numerous full-time employees for a large content owner like Viacom, or deployment of automated systems by copyright owners looking for infringement. Thus, copyright owners have long agitated for alternatives. We'll talk perhaps some in class about this. There were 3 strikes proposals, 3 unauthorized downloads detected, and you lose internet access for at least some period of time. This was attempted in Europe without much success. And these days, a fundamental right of access to the internet is at stake. And both Europe and the US have started to recognize in other areas that access to the internet is basically necessary for modern life. So cutting you off for copyright infringement is an incredibly serious penalty. In the United States, there was a voluntary agreement between content providers and major internet service providers in 2012 to implement a 6 strikes regime. It was abandoned in 2017, and there is little political will to cut internet access to households as a result of misbehavior by individual subscribers. Some copyright owners are trying and perhaps succeeding in creating a user cutoff requirement by suing internet service providers, that is the people who provide the core sort of Wi-Fi service or cable internet, for facilitating infringement if they don't respond to notices of claimed infringement. And sometimes they succeed at this, including some billion-dollar judgments against these core providers. And because those aren't CND providers, the safeguards, minimal as they are, that exist for CND don't exist for those. And that is a growing problem. Now, big copyright owners are all about trying to get politicians to require filtering at the host level, because attempts to get filtering by access service providers like Verizon and Cox failed. So Europe just mandated that your user-generated content sites have to use filtering technology, but how that works is yet to be determined. The real work to benefit big copyright owners is going to be done not so much by the filtering, but by Europe's additional requirement that sites must take licenses from collective licensing organizations and pay them. Again, how this will work out in practice has yet to be seen. So we'll return to this in class, and I will see you then.